even if you do go to trial, you need to ask these questions because you just can't make this stuff up. Yeah. Now, I'm trying to throw some content out before I get to the gym because y'all know I've been on my Portia Glow Fitness. And by the way, go follow that page. Because everybody thinks that the fight is just about not taking a plea deal, but baby, you're wrong. But let me tell you something, even if you do go to trial, there are questions that still don't get asked, baby. Questions that don't get asked. But don't worry, I'll put you on game. Now go ahead and grab your pen and pad because my friends, that's where cases fall apart. Now here's what people miss at trial. In many serious cases, like homicide, drugs, assault cases, the jury hears emotional testimony. Family members, and half of them mofos don't count for nothing, and y'all know I'm telling the truth. Inconsistencies, and let's not forget about those character arguments. But what really matters legally is elements, consultation. I said consultation. Intent, and let's not forget about that proof with reasonable doubt. I said reasonable doubt. Now here's the questions that you should ask at trial. This coat kind of makes me feel like. Anyway, what exactly caused that person to be unalive or harmed? Not what they believe, not what they think that happened. Come on now, they be doing the most. What was the medical cause? Question mark. What physical act caused it? Question mark. What is the scientific proof? Question mark. Was it challenged? Question mark. If the consultation was weak, the case is weak. They need to throw that out. Let's keep going. Number 2, what proves intent? Question mark. For serious felonies, malice requires intent. Felony murder requires a predicate felony. Assault requires intentional action. Ask what action proves intent. And I'm a little sleepy, but I gotta hit the gym. Let's keep going. Is this interference or direct proof? Question mark. Number 3, was every element proven? Every element has a charge, but they won't tell you that, but I will. So listen up. Here's what you ask. Identity, act, consultation. And let's not forget about that jurisdiction, because I did throw out a jurisdiction video in case y'all haven't saw that one. But y'all need to get y'all butts over there and go watch that video. It's going to help you. But who am I to prove to you that it will? I'm not. Let's keep rolling. If one element falls, the charge falls. Domino effect. But jurors often don't break it down to you, but I will. Unless it's explained clearly. And 9 out of 10, half the jurors be on some I'm ready to go type of time. Like, who want to sit there all day and listen to all this boring stuff because they're not really interested in it. But did I say that this was legal education purposes only? Yeah, I feel like I'm being a little too much right now. Maybe because let's keep going. Number 4, were forensics experts challenged? Question mark. Did defense hire independent experts? Question mark. Cross-examine the medical examiner thoroughly? Question mark. Challenge toxicology? Question mark. Challenge timeline? Question mark. If the state's science goes unchallenged, juries tend to accept it as fact. That's what a period. Number 5, was motive actually proven or implied? Emotion equal motive. Now, I be telling some of y'all women to stay out of y'all feelings because, hey, it can get the best of us. But who am I to say again? Everything. Character issues equal motive. Look at the person's character. It can equal motive. But if it don't line up, you got to challenge it. Make sure you ask, was the legal motive presented? Question mark. Was it evidence or suggestion? Because they be suggesting a lot of things around here. But, 6, were jury instructions clean? Now, I'm going to be honest, and most people never think about this, but I do. But let me tell you something. Jury instructions matter with the capital M. Ask, were objections made? Question mark. Were lessers included? Offenses required? Question mark. Was burden of proof clearly defined? Question mark. These are questions you need to ask. These are questions they don't want you to ask. If instructions are flawed, that matters on your appeal. Or they appeal, he or she appeal, whoever appeal. Going to trial doesn't automatically mean that everything was challenged. That's a period. You have to understand what should be challenged. Trial is not about emotions. It's about elements. Think about it. I hope that y'all play this video again and again and again. And don't be one of those people that say, I don't need this information. Yes, you do. And by the way, checkmate. Don't forget to like, share, and follow, and repost again and again. Now let me go hit the gym. Talk to you later.